Hi, everyone. Welcome to the panel about operationalizing content moderation, top 10 best practices. I'm Karen Kramer. I'm general counsel at Quora, which has the mission of sharing and growing the world's knowledge and has a lot of user-generated content. So I feel well positioned to be able to be the content moderator today with our distinguished panelists. And I'm going to start by having them go down and introduce themselves so you have a better idea of where they're coming from and how they can shed light on what we're going to be talking about today.
Sure. Thank you, Karen. My name is Salman Alam. I am Assistant General Counsel at Western Digital for product development. Western Digital makes data storage products. You may know us more for our SanDisk USB sticks and microSD cards, but we've also recently been launching cloud services platforms as a new business line, and primarily kind of focusing, going to provide some perspective on that. I've also worked at a couple startups in the internet space. And just to kind of keep in mind, the idea for a lot of content moderation legal regimes was to actually protect new business ideas and innovation that may actually be under fire here in the recent days. So hopefully looking forward to talking about that.
Hi, I'm Zach Cox. I'm a lawyer at Reddit. To make sense of the perspectives that I can add today, it'll be helpful to know a little bit about what Reddit is and how we work. Some of you may know it, some of you don't, so bear with me for a second. It's a content platform that's organized as a network of communities. The communities are sort of known as subreddits, and they're run by volunteer user moderators. The moderators have a fair bit of authority to organize their communities and to set up rules and govern them how they'd like. The site has several 100 million monthly users, which I mention only because the company is relative to that number is relatively small. We have fewer than 500 employees globally, and as recently as 2 or 3 years ago, that number was closer to 100 or 200. So as a result, the content moderation strategies we employ involve the user moderators a lot, and that leads to interesting interactions with the new content, or the existing and arising content moderation regulation regimes.
Hi everyone, I'm Mark Fiore. I am in Facebook's legal department. I oversee the team that handles our compliance with IP laws relating to user-generated content. So obviously covering copyrights, trademarks, counterfeits. Obviously, as content issues have gotten more attention over the last year or two, my team and others in the company have been focusing on a host of other issues as well, including enforcement of our community standards, which is our own internal policies dictating what can be posted and cannot be posted on Facebook. I think one of the themes that I'll hit on today is certainly one of growth at Facebook. Just as one example, when I joined the company 5 years ago, there were 2 lawyers on the team focusing on these issues. On my team today, there are 14 lawyers focusing on these issues, and that's just a bunch of lawyers. To take the IP operations team, which is the team that we work most closely with, 5 years ago, that team had about 30 people on it, and today there are well over 200 people on it. So that's just in relation to IP. We'll touch on a little bit more about that, as well as some of the non-IP issues as well.
I'm Eric Goldman. I'm a professor at Santa Clara University School of Law. My teaching and research focuses on internet law. And starting at the beginning of last year, I helped organize a series of 4 conferences on content moderation, the first one being in Santa Clara in February of 2018, that tried to look at the operational practices under the hood that internet companies were deploying, trying to expose some of the diversity of those practices and identify some of the various challenges that companies were running into and how they were solving them. And we'll talk a little more about that, I'm guessing, as it comes up.
Great, thank you all. So for our first question, let's talk about how we respond to what's going on in the world out there. It seems like a lot of rules and expectations are toughening against platforms. We have courts chipping away at the scope of the DMCA and Communications Decency Act protections. We have Europe and other foreign countries creating new laws and ways to regulate us, our own Congress calling for new ways to impose liability on platforms. I'd like to talk about what each of you considers the top 1 or 2 biggest one of those challenges, and then even more importantly, not just how they concern you, but what are you doing about them? How do you operationalize those concerns? Mark, let's start with you.
Great. So I can start. I'm going to talk a little bit about the copyright directive that was just adopted in the European Union and what we are doing to comply with that. I should note, though, at the outset that Facebook has long welcomed smart legislation. I think there's a perception that folks in Silicon Valley are adamantly opposed to all kinds of regulation. That's not true. Certainly, speaking for Facebook, we do, in fact, welcome smart legislation. And I and many others at the company spend a large amount of our time interacting with regulators to discuss what potential regulations could look like. The trick, of course, is that the regulations need to be smart. You know, some of this can be done right, some of it can be done wrong. And I think the copyright directive in Europe is a good illustration of some of those challenges. So just for a little bit of background around, about the copyright directive, in case you're not all familiar with it, it was an attempt by the European Union to essentially modernize and harmonize copyright laws throughout the member states in Europe. It was finally, after many years of debate and back and forth, approved, I guess, about a month ago now in the final vote. Covered platforms will have about 24 months at the sort of outer limits to comply with the law as the member states go ahead and implement it. There are a lot of controversial provisions in it. Probably the most controversial is Article 13, or now with the renumbering, it's known as Article 17. And essentially what that provision says is that certain platforms need to put in place measures to obtain authorization for copyrighted content that users are uploading. And for content that authorization has not been obtained, they need to put in place measures to prevent the availability of that content on the platform. So essentially we're talking about a world involving licensing and filters. The regulators like to say that the law does not actually require filters, but as the law essentially indicates, it's basically impossible to comply with it without putting in place filters. So what are we doing to comply? We've talked a fair amount about this over the last couple of years as part of the debate, and I'll highlight a couple of things. So Facebook has launched a system called Rights Manager. It's our tool that we've had in place for a couple of years that allows copyright holders to protect their video content essentially at scale. The way it essentially works is that rights holders can put their video content into our Rights Manager system, and then every time a user uploads a video that matches that content, the rights holder has a number of different actions that they can take. They can choose to block the content at the outset. They can choose to monitor the content, which essentially means sort of tracking the views of the content. They can monetize it, which involves claiming the ad revenues that may be associated with the video, or they can report it for removal to our IP operations team that I mentioned. That's what we've had in place for video over the last couple of years. It is incredibly complicated. There are a lot of limitations to it. People like to figure out ways to game the system. If someone speeds up the sort of audio in a video, then we might not be able to detect that, for example. If people crop the video, we might not be able to detect that with the technology. All of that is leaving aside issues like fair uses or copyright exceptions in Europe, license uses. I can't tell you the number of times that we've had one major rights holder try to remove content only to discover that the affiliate of that rights holder in Australia or somewhere actually did have the rights to upload that content. So there are a lot of challenges that are associated with tools like these, but that really is the future under the copyright directive. I should note as well, it is not limited to videos. It applies to all copyrighted content. So these are hard questions that we're sorting through right now. That applies to photos. It applies to text. Text could theoretically mean ebook files. It even could potentially go so far as to if someone copies and pastes a poem, we might need to do something with respect to that. We expect our Rights Manager tool to sort of be the cornerstone for all of those issues as we continue to sort through them. That's on the filtering side. Just real quick, I should emphasize that really the copyright directive is intended to result in authorizations or licenses for copyrighted content, or at least so says the regulators that have put forth the law. really there are not any sort of large-scale licensing schemes in the world right now, with one big exception, that's the music industry. As many of us know, that in and of itself is an incredibly complicated licensing regime. We at Facebook have, over the last year or two, entered into licenses with most of the major music entities across much of the globe, and that will continue to be the practice going forward, certainly under the copyright directive. The question for us is then going to be, what do we do for photos? What do we do with book publishers, things like that, where there isn't any sort of real scaled out licensing regime in place. So stay tuned for that.
Salman.
Yeah, so I'll talk a little bit about the U.S. here, not necessarily on the IP side, as Mark just thoughtfully did, but more on kind of content moderation, generally focusing on the Communications Decency Act, FOSTA, and a little bit about how you, if you don't have 14 lawyers and 200 the resources for all the resources that the kind of major companies have, how you can kind of go about and still meaningfully develop your platform, help your business doing so. And I think, as Mark thoughtfully mentioned, smart legislation is the key for us in the Valley to develop meaningful product lines and business models. There has been no smarter legislation than the Communications Decency Act of 1996, which essentially laid out the the legal regime for the innovation that you see right now, in the sense that these 26 words that no user or provider of an interactive computer service can be treated as the publisher or speaker of information from another information provider. So this specific exemption and kind of immunity from this type of liability from a third party has been essential for all of these platforms. But that has kind of started to erode a little bit, most notably with the enactment of FOSTA, which is the Fight Online Sex Trafficking Act, that essentially, which was passed, I believe, in April 2018. Donald Trump, President Trump, signed that at the time. And it has a lot of different kind of implications, but primarily the idea here is that as an online platform, the immunities that you had under the CDA, because it amends the CDA, to either facilitate or promote illegal sex trafficking or prostitution, was no longer there. That's a significant blow. There's been a lot of blowback from a lot of companies as a result of that. Craigslist has taken off its entire personals section. Other platforms here can speak to what decisions that they've made, but that's a significant change. And I'll say two things about FOSTA to the accent. First, this wasn't like a law that just kind of eked over the finish line, right? It passed the Senate 97-2. This is not like some sort of kind of aberration as to where the political climate sits at the moment. Primarily right now, and the only two people that did say no to FOSTA were one, Ron Wyden, who actually helped draft the CDA, and then second, Ron Paul. We'll get back to Republicans in a second. But that is a significant kind of trend in the House. I think it was 384 in support. So it was a pretty important thing. Since then, the kind of rhetoric has actually ramped up on both sides. So you have Senator Hawley from Missouri, who's kind of made it a major issue even before he assumed office as a junior senator from Missouri. Nancy Pelosi is the speaker last month, saying that she feels that the CDA was a gift to tech companies that they may not be using appropriately, and so CDA immunity may be in jeopardy. So those types of things, and the House Energy and Commerce Committee here in the U.S., the meaningful, or the committee that actually engages in oversight of this particular statute has already planned hearings to talk about that. There's actually, I think, one piece of legislation by Louis Gohmert that actually exempts social media companies altogether from the CDA. So that is, where that goes, obviously, I don't think that may be hard. But I was talking to Professor Goldman about this earlier, if there is a legitimate proposal made by the House majority to amend the CDA in some meaningful fashion, there is a good chance that it may pass. So we're not sure about that, but that's one thing to talk about.
Salman, there's so much that's going on that we can trace into details.
Yes.
No, I just wanted to focus on the operationally, what you're doing about it, because I think we could write textbooks and have a whole day on all the developments that are going on or that we could worry about. But what are your solutions? So
the solutions are that you can still have a business model that is based on user-generated content. And the key is basically when you work with your business unit or your GM, and if you don't have a massive legal department, if you don't have a considerable amount of resources at your disposal, AI, as long as you're kind of focusing on the main precepts of the CDA that have established pretty strong immunity, because the CDA, when it was actually passed, still relied heavily on the federal and state courts to consistently buttress the fact that, yes, this was a very clear immunity for third-party content. So if you're in e-commerce, if you're in social media for the most part, if you're in a data exchange, if you're in a platform that allows communities to collaborate, I think they're still very much so okay. The idea of whether or not, and a lot of it's also going to depend on how risk-averse your management is in terms of going these types of things. So I think Craigslist made the decision not to, if anybody's from Craigslist here, please feel free to correct me, publicly made the decision not to do this because they didn't say that when it came to FOSTA, they were going to not be able to moderate effectively, so why moderate at all and even have this liability. It wasn't worth it to them. So that was going to be kind of the keys there for us.
Great. Seth?
Sure. So first of all, both the copyright directive and the FOSTA incursion into the CDA are big things that Reddit thinks about too. I'll talk about one or two others. The first is the NetzDG law in Germany. If you don't know about it, that's probably okay if you don't have like 2 million registered users in Germany. But even if you don't, I think it's a useful model for looking at what laws that require certain levels of content moderation can, like the harm that they can do when they're prescriptive, and what it means for content platforms. So although it is a reactive law, so nothing's triggered until you learn about the violation. Unlike the copyright directive, which has these proactive filtering requirements, even though it's reactive, it's very prescriptive about what you have to do. The result of the law, the way the requirements are set up, mean that you have to determine whether content is manifestly illegal under something like 1 or 2 dozen specific German provisions within 24 hours, which is hard to do for a US-based tech company. It also, like, if the subtext there of like you must be familiar with the German legal system is not clear enough, you have to have people on staff who have German language proficiency, and you have to train them and do all these things. And the law, as maybe German laws are wont to do, is very prescriptive about how that has to happen. I wish that I had a lot of good things to say about how to operationalize that. I mean, if you don't have 2 million registered users in Germany, this one is going to get away from it. But more generally, when looking at content regulation, the more prescriptive it is, the less creative you can get. And one of the benefits of CDA 230 was that companies could develop new and creative solutions as to how they were going to moderate content. If you have to have somebody that speaks German and you have to write German language transparency reports, you start to lose that freedom to come up with cool solutions, and are stuck throwing the level of resources that the people who wrote the law had in mind that you might have. For a company of 400 or 500 people, most all of whom are in the US, that can be tough. The solution that we have, and if it doesn't work for you, I'm sorry, is the legal operations person we'd hired like 6 months before the law came into effect happened to be fluent in German and have a legal degree, and so that worked really well for us. Although it also means that sort of on 24 hours notice, he has to decide whether something is illegal in Germany.
Just to clarify, is it notice-based, or you're saying?
Yeah, it's notice. So it's
after someone complains.
After someone complains,
yeah,
right?
So it's not like you have to know everything that goes up.
Right. So another thing that you have to do is have a reporting system for people for just anybody to be able to give you notice about content on the site, and that has to be in German. And because the specific German statutes are laid out, what it's basically said is you have to design a reporting part of your product. In other words, a user reporting flow that's basically looks like this. So that's an engineering thing. Another thing that I can talk about quickly is it's coming from inside the house. It's this Mavericks v. LiveJournal opinion that's now about 2 years old, but deals with the safe harbor under the DMCA when a company uses volunteer moderators. So really quickly, the background of the case, LiveJournal was the defendant. The the result of the Ninth Circuit opinion was that the Ninth Circuit found a genuine issue of fact as to whether volunteer user moderators of this particular LiveJournal community, which from the opinion sounds like a lot like a subreddit, were agents of LiveJournal, such that the material that the mods approved to go up on the community would not be eligible for the safe harbor for material that's stored at the direction of the user. The key takeaway, I think, from this opinion is that it really drove a wedge in between two things that people often think of similarly, which is the safe harbor for material infringement by reason of storage at the direction of the user and information provided by another content provider. Generally, you think of user-generated content. Okay, both of those are going to be, if it's a copyright issue, we're going to deal with it under 512C. If it's not a copyright issue, we're going to be okay under Section 230. The distinction here was that although the information was provided by a third party, it's user-submitted content, this community had moderators that were able to pre-screen the content before it went live. It sounds like they pre-screened about 2/3 of it out. They were searching for juicy celebrity gossip. If it wasn't that, they weren't going to post it. But if it was that, they would post it. And as a result of that pre-screening, these volunteer user moderators were the gate for the public accessibility of the content, and therefore the court held that they might be agents of the service provider of LiveJournal, and therefore the material would not be stored at the direction of a user so much as like stored at the direction of those moderators. Now there's some play in there because storage at the direction of the user is really by reason of storage at the direction of a user, and because the public accessibility of the content is the key moment that the court looks at as whose action matters, and there it was the moderators as opposed to the original users. And that gets to one of the possibilities for thinking about how you could get around that decision, get around if that's the way you're looking at it. One is if material is posted immediately rather than pre-screen, it's hard to do what the court did there and say that the agents were the moderators were agents because the moderators were pre-screening and posting it. If it goes up live immediately and moderators only remove it after the fact, that distinction is a little bit harder there would be a way to distinguish that case. It's not clear from the opinion, and I don't think there's clarity afterwards as to whether the public accessibility of the content is really the thing that the court was hinging on, but that's certainly a way to think about it. More generally, just giving moderators freedom to set the rules and moderators more freedom to do what they want to do in their community. Reddit is quite good about that, I think. We have lots of different communities that cover lots of different things. Moderators can establish all kinds of rules. There are great, crazy examples. I won't get into them here, but they're like inane ones and really focused ones. And being clear with users about the scope of the moderator role. There were some really bad facts in the Maverick Speed LiveJournal case. It turns out that the moderator was not, in fact, a volunteer user, but was like an employee of LiveJournal, which hurts the agency position. But clearly communicating the role of the moderator, giving moderators freedom, and thinking hard about whether moderators are allowed to pre-screen content are ways to avoid that wedge that can get driven between CDA 230 and, on the one hand, and 512C on the other.
Thanks. Eric, do you have any other thoughts to add about a best practice on the pre-screening or post-screening of content issue, given what's going on in the case law?
Yeah, a few things to say. Historically, we've taken the position that we can pre-screen or do post-hoc review. It's all good. It's all equal for us. And in fact, there's some types of content where pre-screening is not functionally available. So, for example, live broadcasting. Either we don't allow pre-screening or we don't allow live broadcasting. We have to pick one. But we could generalize it more and think about things like Twitter. Imagine that there was a 1-hour pre-screening review for Twitter. What would Twitter look like at that point? It would be something interesting, but it wouldn't be Twitter. It would be something different. And so we still are going to, I think, be interested in fighting for the opportunity to pre-screen. the services that need it really do need it. Otherwise, pre-screening is really just about time and money. There's nothing that says we couldn't pre-screen every YouTube video. That would be doable. It just would be extraordinarily expensive and maybe not worth it. And this is, I think, the crux of the matter today. How much time and money are we willing to spend to comply with the various laws that are coming in, the various obligations that are coming in, that are imposing this obligation on us. I'll give you the case study of the print-on-demand companies. These include companies like Zazzle, Cafe Press, and a number of others in that genre. So there's been some really horrible cases in that area that have said basically that in one case, the service provider was held to be liable for copyright infringement for the copyright owner's works or print-on-demand functions for those. The only way, on a strict liability basis, the only way to avoid that would be to have identified those copyright works and filtered them out before allowing the print-on-demand function to take place. There's no functional way to actually operationalize that. The only way would be things like some kind of automated, massive database of all copyrighted works in all formats that was perfectly calibrated to identify all the works. You're going to have some errors in that. I'll talk about that in a moment, but at least that would work. But those databases don't exist. So given that, there is no way to operationalize that. You couldn't even operationalize it with humans because there's no way for humans to figure out which works are copyrighted or not. Even if you were to say, here are the 26 works that were at issue in this particular case, then you have to train all your staff to make sure that they look at every item that goes through the system to find those 26 works, assuming they can remember them. But you multiply that by hundreds of millions of copyright owners, and it suddenly becomes impossible. Another case involved a T-shirt printer that was printing variations of the Harley-Davidson trademarks. And the court issued an injunction saying you cannot do print on demand for any of the following trademarks of Harley-Davidson or any substantially similar variations. Now, that's standard under trademark law to cover not only the verbatim versions, but substantially similar. How do you operationalize the substantially similar part? That is not amenable to setting up filters, either keyword filters or image precedent filters, because they need to pick off not only the identical versions, but substantially similar versions. Mark already indicated there's lots of ways you can manipulate source material to make it so that the filters won't recognize that it's identical, and there's no way to pick that up under a substantially similar framework. So there really is no functional way to do the kind of pre-screening that's going to be required for the print-on-demand companies in both copyright and trademark sense. So
what's a company do? Just open their checkbook out to...
Well, yeah, they're basically going to resolve the cases at hand and hope that the trademark and copyright owners don't all pile on. Because if they all pile on, none of the print-on-demand companies can exist. They will all go out of business. The other thing that we've seen, there was one successful defense in a case like this where the print-on-demand company outsourced every function of its business except for the marketing function. So they outsourced the actual manufacturing. They outsourced the actual fulfillment, shipping. They outsourced the payments. The only thing they did was ran the database and then had everyone else on the hook. Now that's great as the intermediary. You're not liable for any of the pieces that those vendors do. But the moment those vendors go out of business, you still can't succeed. The print-on-demand company industry as a whole cannot survive the pre-screening requirements the courts are going to impose on it. This is all under U.S. law. We haven't gone to the crazy stuff outside of the U.S.
So what are the implications for non-print-on-demand?
Well, so this is the lessons to learn, which is look at the challenges we face as more laws are putting more burdens on pre-screening. We've always assumed we can do the post-hoc reviews and we're good, and the laws are ratcheting up the pre-screening. The more that we're going to do is rely on these automated filters. So, for example, with the terrorist content, there's an entire database that you can subscribe to, the GIFCT database, that will allow you to have the precedent set for you by other companies. They all upload the works that they blocked, and then you can just automatically block those as well. Isn't that great? That solves your problem. You don't even have to have humans do the work. You simply allow the database to do all the work for you, except that assumes that everything that was uploaded into that database was accurately identified and is actually illegal, which we have no way of even knowing because we have no transparency of what's in the database or that there's no way to correct any errors that were introduced into them. So this is going to be the problem. We're going to have over-inclusive removals based on the filtering that we do. Last thing I'm going to say is that the real end game to all of this is the end of user-generated content. We're going to move to a model of professionally produced content, and that's all that's going to be available. We're going to go back to the cable system circa mid-1990s, that the only thing you're going to get on most of the sites that you now call user-generated content is actually going to be professionally produced content where the professional producers will take all the legal risk as well as you. They'll set up an indemnity or whatever the case may be, but you're going to opt out of all these laws because you're going to rely upon professionally produced content. The era of amateur content is probably coming to an end.
I hope that's not true for all of our businesses that are based on user-generated content.
That's what we're fighting for. When someone says that they're in favor of smart regulation, recognize the oxymoron. In fact, the only incumbents are in favor of that because they can survive the model of professionally produced content. No.
So some of what you were saying, Eric, about technology, I've heard a lot of mentioning about filtering coming up, and I'd like to ask each of the panelists to speak to the technological versus people-based solutions to content moderation challenges and how you balance those two approaches. Mark, we haven't heard from you yet in a while on this.
Sure. So I think one of the key takeaways here is that the capabilities for technology when it comes to pre-screening is very context-specific. So Eric talked about terrorism content. At Facebook, we now are able to proactively remove 99% of all terrorism content that we deem as violating our community standards. That means that all of that content is taken down by our systems before a user can even report it to us. That is somewhat easier because there are databases of images and there are certain photos where we just know those are known terrorist photos. It gets much more difficult in other areas. So take hate speech, for example. Hate speech is a much more textual issue. And computers, algorithms, machine learning, AI, whatever you want to call it, is just not as smart as we would like it to be at this point. So these computers just can't necessarily detect whether someone is denouncing hate or denouncing terrorism, or instead advocating hate or advocating terrorism. So in those situations, the machines just quite simply don't work quite as well. Just one statistic on that front. So when we really started working on our machine learning and our AI to tackle hate speech a couple years ago, we were at about 24% in terms of the amount of hate speech that we were removing from our platform that was proactive as opposed to reactive. That was in late 2017. Today, we're at 65%. So we've made really good strides there in terms of the technology being able to detect hate speech, but still, it's only at 65% in terms of what's being done proactively versus reactively, compared again to the terrorism content, which is at 99%, or the adult nudity images, which are over 95%. So that highlights some of the challenges that we have with the technology. On the people side of things, as I mentioned at the beginning, growth is certainly one of the themes when it comes to Facebook. We have a very large community operations team that handles the reports that come in from users for content that violates our community standards. Currently across the company, we have 30,000 people working on all safety and security matters. Of those, about 1/2 of them are actual content reviewers on the community operations team. And that's essentially doubled over the last year or two. So we've had massive growth in that regard. That said, I think very much the future really is the technology. And as I noted, the rates of getting at this content on a proactive basis are going up. It also means not only that we're able to get the content down much faster, but we're able to get more of it down as well. The reality is that machines are just able to process much more content than our reviewers are able to do, even with the staffing increases that we've had.
Thanks. Zach, how does Reddit balance the human versus technological approach?
So Reddit's model, like I talked about before, is or the difference between Reddit's model and maybe some other content platform models is the degree to which we give volunteer user moderators the ability to make decisions about what will appear in their community. And the result of a volunteer user moderator's decision about what will appear in their community more or less affects the visibility of that content on the rest of the site. There are some feeds that collect popular content from across the communities, but if it's not popular in a given community, it's hard for it to get popular across the site. So that's how it relates to the sort of default experience that you might get if you didn't have an account and went on to reddit.com. The benefit of that is that the content that does well is content that has arisen in a community that has a lot of people in it, and the community has a lot of people in it because people find it valuable. And the reason that happens is because it's around a topic that people care about, and that somebody has taken their time to create the community around it and follow the moderator guidelines and grow it from from scratch, basically. So it's hard for content to, you can't just post something super inflammatory on and have it just totally blow up on Reddit unless you find some community that's particularly receptive to it. And if you do that, chances are the community has been on the radar of people at the company and maybe has violated moderator guidelines or site-wide rules. So that ground-up approach that involves the volunteer moderators works quite well for us in many contexts. There are, of course, contexts like Mark talked about where there's no substitute for what a machine can do in the pre-screening capacity. So there are industry collaborations around certain kinds of content that you can just identify by, for example, hashing the image. Those have been around for a while and I think are pretty well established and have done a good job. Terrorist content is one around which there's a newer industry consortium, and then there's a much longer established one around child sexual abuse imagery. We use those, or at least we use the child sexual abuse one. I think we use the terrorism one too. And more generally, that's something that because of the liability regime around the CSAI content and the growing liability regime around the terrorist content, that you just can't do another way. Another area where tech solutions are particularly appropriate is for us at least, with using signals that we couldn't pass along to volunteer user moderators. So signals that only we have as the service provider. That's maybe the person's IP address or information about their device that allows us to know whether there's coordination across several accounts or something like that. So there's absolutely a role for both. It's not one or the other. It has to be both. I think people have been saying this now for a long time, but it's especially true. And there's the different challenges that each is appropriate for depend not only on the kind of content and the way in which it violates the law, but also the particular needs of the platform. I think for Reddit, it's going to be different than it is for Facebook, different from Western Digital or other kinds of content platforms.
So Salman, from an emerging technology business perspective, how do you approach the balance of the two?
Yeah, it's a great question. I think I'll focus more on the people side because if you're a nascent business model, you will not have access or the resources most likely to the amount of technology that people are considering to be kind of par for the course right now. So when I say people, it has to be quite literally you framing you as the in-house lawyer or the attorney advising the business team how to develop a meaningful framework for having this conversation. So that just doesn't mean creating the acceptable use policy or developing or just writing it out. It actually means having a conversation about how to govern all of the decisions you're going to have to make. And then eventually you'll get to the technology piece, join the consortiums, as Zach said, those types of things that can leverage what you need. At minimum, the basic things that you kind of have to do, obviously, that are to make sure that you have the system in place. I wouldn't say the technical system, but the system in place to have a conversation about the policy. That means having the product manager involved. That means obviously having the executive leadership involved in the conversation. PR, the other marketing teams themselves that need to be aware of how this company, your business model, is going to be perceived. If you come out of the gate with so I'll give an example. One of the product business models that we're trying are SanDisk makes most of, or a lot of the world's USB sticks. And one of our business models right now is that you can have, if you have a SanDisk USB stick, you can back it up automatically to our cloud, because studies show 30% of you, or us, will lose your USB stick at some point, and you can actually back that up. So it's a kind of a new thing that we're trying to approach here. It's a subscription-based model. How do you frame the conversation when something comes up on that platform, which you then eventually will want to interact with, people will want to share their photos, people will want to share their content? That has to basically quite literally come from the GM of the business to figure out, are they going to be proactive? And then if you're going to be proactive, what the expectations are in terms of resources. And that, once you kind of have that buy-off, or if they don't want to be proactive, then you're going to have to obviously advise on what the risks are going to be. It's product lawyering, but in the context of the fact that this window may be narrowing just a tad. Having said that, I still think that the significant number of the business models right now under the CDA are very much so valid, intact. They keep getting reinforced. So you still have this very strong protection in place.
Eric, from your work with bringing together members from the industry, what would you say you're seeing as far as trends and the balance between the two?
Yes, the regulators want the speed of machines, but the nuance of human decision-making. And so you kind of get to pick one, unfortunately. You have to kind of choose between them. Now, it's not quite as binary as that. In fact, Facebook, for example, has done a really good job about using the machines to help cull the database so that you can prioritize the human attention on the things that are at the hardest point. So the machines and humans aren't opposite to each other. They can be complements to each other. But it takes really sophisticated work to do that properly. There's a weird bias towards human decision-making, which I just want to flag for you. There's a lot of paranoia about the machines, that they're going to go rogue on us and kill us, that they have all these undisclosed discriminatory biases, that they've been miscalibrated, and all that could be true. But we as humans are also imperfect. And so all this human fetishism really masks the fact that humans are also biased, and humans also don't even know their own biases. And so they're making mistakes, and they're also imposing their own views on the world in ways that are not ultimately helpful. Any effort to expand the human review of content online necessarily raises what we call the worker wellness problem. What do we do to take care of the people who are looking at the most problematic types of content? This is a job that is not suited for everybody. In fact, it may not be suited for many people. It's a job that imposes significant stress and challenges on the people who spend their life looking at the worst of the human side of the worst side of the human condition. And so every company that is going to have humans reviewing content also has to build a worker wellness program as part of that. And one of the things that we saw from the content moderation series of conferences is how radically different those worker wellness solutions are, that there is no single standard about how it's done. And so there's a lot of diversity in the worker wellness solutions and opportunities, I think, for us to learn from each other about what are the best practices, what is it that actually is the best. One of the good examples that I saw, for example, is do you have specialists who focus on only one type of content, or do you give people a diverse set of types of content to review because that way they're not just seeing the worst side of content for an entire shift. And there are pros and cons to each of those strategies, and it might be that for certain types of content, you do need specialists, other types of content, you do need to diversify. And so it might be that there's no single answer to that question. That's a good example of the kind of things that we ultimately can learn from each other. When do you deploy with strategy, and how do you make it work best?
Thank you.
If I can just add on a little bit to a couple of those points that Eric raised. Worker wellness is an important issue. I think this work is new in the world. We've never really had something like this where we have people looking at content, some of which can be graphic, violent content, nudity, difficult stuff to look at. At Facebook, we've put a lot of focus on that. Even in the last couple of months, just recently, we announced a number of new features for our content reviewers, ranging from an increase in wages for them to trained on-staff counselors that are available for the entire shifts of the reviewers rather than just dedicated hours, Even more nuanced features like giving reviewers the opportunity to decide whether they want sort of the images grayed out before they actually click on it to see what the review is, rather than just having an image appear right in front of them that could be, something that's quite graphic. So those are a couple of examples of things that we've been doing. Again, it's really still pretty early days for a lot of these issues, but hopefully others will be adopting some of these practices as well. To be sure, I won't say that Facebook is perfect when it comes to this. We've made mistakes and we'll continue to make mistakes, but we're focusing on what else we can be doing in that regard. One other thing I wanted to note as well, going somewhat to the bias point, but we have recently launched what we call our External Oversight Board, which is a pretty novel way of thinking about how to address content on platforms. This External Oversight Board is going to formally take shape over the next year or so here, but essentially the idea behind it is that we don't want Facebook to be in a position to be making all of these difficult content calls. All you have to do is look at the news or go onto Twitter and see what people are saying about calls that we're making in relation to content that users are posting. So the idea here is to have an independent outside body of experts from a number of different fields, civil rights, free speech, safety, that will be able to review some of the content decisions. And essentially, it's the last level of appeal for those ones that do go to the board. And then we will be bound by those decisions, and then they will also help us in terms of, where appropriate, revising the policy guidelines that we've put in place. So that's new. We're excited about it and should be rolled out sometime in the next year or so.
Historically, content moderation was very much held on the back end by platforms, and there have been a lot of increasing pressure to be more transparent and public about their decision-making process. I'd like to hear how you all have been responding to that. Zach, can you speak on that for Reddit?
Yeah. When we talk about platform transparency and being more public about what the decisions the platforms are making, I think that there are a few aspects to that. One is sort of the due process interest of the user themselves, whose content is moderated in some way, So along that line, we've done a number of things to make it clearer to users when their content is removed or if they are suspended from the site, the reason for that. The challenge on Reddit is that you might be suspended from the site, you might have your content removed from the site, or more likely, you might have your content removed from an individual community, or you might be removed from an individual community. And the communication around that is really up to the moderators because their standards, like they control the standards for who gets to post in their community or who doesn't, what content gets to go up in those communities. So around that, we have guidelines for moderators that say, that describe the best ways to engage with the community, that make clear that secret guidelines are not helpful. And we're working on tools that give them the better ability to make those, or to reflect those decisions back to users. It's easier when the communication is just between the platform and the user, that because you control the messaging and you control the site-wide rules and those things. So the due process interest for the user is one thing. Another thing is the more general public communication aspect that you see with transparency reports that sites publish. Along those lines, we've tried to include not only raw numbers, which I think if all you're looking at is a single transparency report may not be that meaningful, but to compare them, to put them into the context that people will find helpful. So we do say, like, this is how much content gets removed by moderators versus by us. When we remove content, it's for these particular reasons. Like, these are the site-wide rules that like the breakdown of how we look at those things. And we also include specific examples, which I think are particularly helpful in bringing to life what it looks like when somebody does violate one of those rules, and try to say this is a case where this is what we saw and this is what we did. Those have long been, I think, they started along, I don't know, when platforms started to put them out, they were mostly about government or speech or moderation decisions made in response to removals, either for copyright reasons or because of a government takedown request or request for user information. We've started to put decisions based on our own rules, what I think Facebook would call its community standards, in our transparency report also.
Let's hear from Mark next from Facebook, and then with probably the last 5 minutes, I will open it up for people to come to the mic for any questions. So Mark, how about you? How is Facebook, or how about speaking for Facebook in terms of responding to these pressures to be more public and transparent with what your standards are? How are you operationalizing those pressures?
Yeah, transparency is a hard issue. What is transparency? What is the point of transparency? Why do you want to know the family history of our content reviewers? It really gets into a lot of nitty-gritty oftentimes. And there can be very legitimate reasons not to disclose all of this information. Just look at the shooting that happened at the YouTube headquarters last year, which targeted content reviewers at YouTube. There's less disturbing reasons as well. Take content violations like counterfeit goods or spam or fake accounts. Those are often associated with monetary endeavors. And so people who are making their living off of these activities are going to be bound and determined to figure out ways to game our systems. And they're going to have an easier time at doing that if we tell them what all of our policies and procedures are. All of that said, we too have gotten much more transparent over the last couple years and even the last couple of months across the board. So we have, since 2013, actually, as Zach noted, released a transparency report at that point covering government requests, particularly for user data. That continued for a number of years, and then we extended that in 2017 to also apply to intellectual property. So now we release a transparency report that provides information around our various IP policies and around data with respect to the content that we remove in response to copyright, trademark, and counterfeit reports. Much more recently, over the last year, we've also been releasing information about community standards removals as well. So that gets into the terrorist content, bullying and harassment is an example much more recently of data that we started to disclose information on as well. And that's the trend. We'll continue to be releasing more and more of that information going forward. I should note one other thing as well. In addition to these transparency reports, which provide information about the actual removals, we also have released our internal guidelines relating to the removals. So our community standards have long been public. What were not public were our internal guidelines that our content reviewers use to assess whether content should be removed or taken down. We published those guidelines, I think about a little over a year ago now, so that people can see, what considerations we take into account when there's particularly nuanced cases, whether something might be hate speech or not hate speech. And we're also using the feedback that we've gotten from people who have looked at those guidelines to help assess whether we should be changing any of our policies. So there have been a lot of benefits from these transparency efforts. That said, as I noted, it's also just a very difficult issue for us.
Can I add one quick thing?
Sure.
There's one approach, this is burying the lead a little bit, but one approach we've long taken and that has worked really well for us. Reddit is the home of the AMA format, the Ask Me Anything. That's one of the things that the site is best known for. Every time we update our policies or make a big product change, somebody from the company goes and does an AMA about it. So we get questions not only from users, but from all kinds of people. And this goes to, I think, the point that you're making about what is the point of transparency and who are you doing it for? The transparency reports are products with a lot of cooks. There are a lot of people involved in producing those things. And when we do the AMAs, we get to serve all of those stakeholders by directly fielding questions from them. And we often learn things that are important to people that weren't immediately obvious at the outset.
Does anyone have any questions they would like to ask the panelists? If so, I ask you to come to the mic so that it can be captured by those who are filming this.
So I'm Mike Godwin. I just want to respond. I want to ask a question that follows a little bit from a comment from Eric earlier, which is that we recognize that machine-mediated filtering is going to make certain kinds of errors, and we also recognize that human beings also have bias, and we also recognize, just from experience, if nothing else, that using both of these together leads to inconsistent results. People will complain no matter what we do. And so the question I have is, you know that when you are filtering content for whatever criteria, through whatever mechanisms, the response will be from users. Number one, you censored the wrong stuff. Number two, you censored too much. Number three, you didn't censor enough. And in fact, the fact that you are engaged in content moderation means that it increases the expectation that you will censor more. So I would like you to maybe respond to the fact that there doesn't seem to be a technology or human staffing solution that really addresses this stuff comprehensively in a way that helps the industry players recover kind of from the reputational damage that they have endured in recent years.
Yeah, I would say you're right. I joke with my team that our job essentially is to make everyone unhappy. No matter what decision we make, someone is going to be upset with that decision. Whether it's a mistake that our reviewers make, and we see essentially for community standards removals, about 1 in 10 of the decisions right now is currently a mistake. With the technology, we're aiming to get that down to like 1 in 100. But with the amount of content that's posted on Facebook, even at 1 in 100, that's a lot of mistakes. And that's not even to mention the issues where it's not a mistake, but it's Ted Cruz disagreeing with the decision that we made because he viewed it as anti-conservative or whatever the case may be. It is in some ways just a reality that we need to live with. Our hope with things like the External Oversight Board is that it will help address some of those issues. But yeah, it is the reality.
Eric, do you want to add to that?
Yeah, there's a perception there's a platonic ideal of content moderation, that if you just threw enough time, money, and intelligence at the problem, we'd come up with the perfect outcome. And I think what we need to do as an industry is educate everyone in the world that cannot occur, that content moderation will always make winners and losers, and that the losers will always be unhappy with it, and they'll always have bases to challenge the decision. So the more that we feed into the idea that we can just come up with a perfect outcome, the more actually I think we're taking us away from the right outcome.
Okay. We only have 2 minutes left, so we could probably take one question and one answer from one panelist.
Hi, thank you. I was wondering if you could talk a bit more about how you think about this on the international scene, and if you think whether that content moderation will lead to like a common denominator of unacceptability, or we'll see a lot of fragmentation on geographical basis.
So I can jump in on that as perhaps the most global platform at the moment. So here too, not surprisingly, it is a very hard issue for us. Obviously, operating at scale, we want to essentially try to universalize things as much as possible. And we aim to do that where we can do it. That said, there are times where it just does not make sense to do it, and we are happy to not do that. So the NetzDG law is a good example. We had to set up an entirely new system for Germany, essentially, in order to comply with the NetzDG law. We obviously, with respect to the CDA, have the benefit of that in the United States, but that obviously does not carry over to the rest of the world. The copyright directive is another great example. There are member states in the EU that have wildly divergent views on what the copyright directive should look like in terms of actual member state implementation. The question for us is going to be, are we going to put in place 28 or 27 different regimes to comply, or are we going to put in place one regime that will apply across the entirety of the EU? There we have the benefit of not knowing yet because we need to see what the individual member states do. But similar with what we've done with respect to NetzDG and with respect to the CDA in the US, if it makes sense to do it, we will certainly look at situations where we might diverge from a more standardized approach.
So I want to thank the panelists for bringing their great ideas here. We'll be available to answer some questions during lunch and a little bit after this panel, but I think at this point we need to wrap up for lunch, so thank you.
Thank you very much for a great panel. We have lunch outside.